Good morning. Thank you for joining Mayer Brown's Global Financial Markets teleconference series. Today's call is entitled Consumer Loan Securitizations, what the recent decision in CFPB versus NCSLT might mean for the industry. My name is Ori Lev, and I'm a partner in Mayer Brown's Washington, D.C. office and a member of our Financial Services Regulatory and Enforcement practice. I represent financial institutions and other companies in government enforcement matters, internal investigations and litigation, and provide regulatory advice and counsel on federal consumer financial law. First, a couple of housekeeping items. As regular listeners will know, this call is being recorded. We will be emailing an audio link to all participants should you wish to listen to the teleconference again or forward it to your colleagues. In addition, the recording will also be available as a podcast on your preferred podcast platform. Since we will not have a Q&A session, please send your questions regarding today's topic by email to gfm@mayerbrown.com, and we will respond promptly. This is the same email address on your invitation email. Joining me today are Mayer Brown partners Barbara Goodstein and Stephen Kaplan. Barbara Goodstein is a partner in the global finance practice of Mayer Brown's New York office. Barbara specializes in financing transactions for a wide range of asset types, including transportation equipment, intellectual property, and other esoteric assets. She also has extensive debt workout and restructuring experience both in and out of bankruptcy. Barbara is a featured columnist for the New York Law Journal's Securitizations section, a fellow and former regent of the American College of Commercial Finance Lawyers, and a former member of the Board of Editors of the Uniform Commercial Code Law Journal. Stephen Kaplan is a partner in Mayer Brown's Washington, D.C. office and the firm co-leader for the firm's Financial Services Regulatory and Enforcement Group. He concentrates his practice on matters related to consumer financial products and services and represents clients in federal and state supervisory matters, investigations, and enforcement proceedings. He also advises clients on compliance with federal and state laws governing licensing and practices of financial institutions, mortgage lenders, consumer finance companies, loan services, and more. With that brief introduction, we will now begin today's discussion, and I'll turn it over to Barbara.
Thank you, Ori. So as a preliminary note, I just want to mention that we've been directly involved with the National Collegiate matter for a number of years as non-litigation counsel for a client. First, some background. The National Collegiate Student Loan Trusts are 15 Delaware special purpose statutory trusts that hold over 800,000 loans, totaling about $12 billion, making them the nation's largest owner of private student loans. These loans have been financed by about $15 billion face amount of investor notes. The trusts were established by First Marblehead Corporation between 2001 and 2007 to acquire and securitize private student loans originated by various banks. The loans were guaranteed by a Boston-based not-for-profit company called the Educational Research Institute, or TERI. First Marblehead owned 75% of the residual interest in these trusts, and TERI owned the remaining 25%. These trusts have a very complex history and are the subject of several pending litigations, and we unfortunately don't have time to walk through these today. However, I will touch on a few key events. First, in 2008, TERI went bankrupt. Then, between 2009 and 2012, Vantage Capital Group, a Florida-based hedge fund investor, acquired all of the residual interest in the trust for pennies on the dollar, and then First Marblehead resigned as special servicer and was replaced by U.S. Bank. Then, in 2014, Vantage instructed the owner-trustee, Wilmington Trust Company, to appoint a Vantage affiliate as special servicer for defaulted loans, pursuant to an agreement that would also allow it to purchase those loans at 10% off the fair market value. It then directed the owner-trustee and primary servicer to stop sending loans to the existing servicer. This agreement was challenged in court by U.S. Bank, a challenge that was ultimately upheld. Then, fast forward to 2017. In September 2017, the CFPB filed both a proposed consent judgment and a complaint against the trusts in Delaware Federal District Court, and at the same time, it entered a consent order against one of the trust subservicers. The proposed consent judgment, signed purportedly on behalf of the trusts by counsel appointed by Vantage, sought, among other things, to impose restitution, fines, and penalties of almost $20 million on the trusts for improper servicing activities in violation of the Consumer Financial Protection Act, require an audit under the direction and control of Vantage of all 800,000 loans, place all cash collections from those loans in an account under the control of Vantage pending such audit, except there was permitted payments to note holders necessary to avoid an event of default, and then create a board consisting of Vantage as a residual holder that would control the trust. In May of 2020, the proposed consent judgment was dismissed based on a finding by the judge that it was not properly authorized, including that authorization was required by Wilmington as owner trustee, and approval by Vantage was not sufficient. I'll now turn back to Ori to discuss the complaint, which remains pending at this time.
Thank you, Barbara. So as Barbara said, in 2017, the Consumer Financial Protection Bureau sued the trusts based on debt collection activities of the trust servicers and subservicers. And the debt collection, the CFPB's complaint centered on the debt collection lawsuits that had been brought against student loan borrowers on behalf of the trust and in the trust's name. That is, the relevant trust was the named plaintiff in each of these collection lawsuits. And the complaint alleged that many of these collection lawsuits constituted unfair or deceptive acts and practices for various reasons, including the fact that various affidavits were submitted in connection with these lawsuits in which the affiants claimed personal knowledge of records that they lacked. Affiants claimed to have reviewed the chain of title and dates of transfer of the underlying loans, and they hadn't done so. Some of the affidavits were alleged to have been improperly notarized, that is, they were executed outside the presence of a notary. In some instances, the CFPB alleged that lawsuits were filed where the trust lacked a complete chain of assignment demonstrating loan ownership, and in other cases, the lawsuits were filed after the statute of limitations had expired in the state where the lawsuit was filed. The same day that the CFPB filed this lawsuit against the trusts themselves, it also issued an administrative consent order against one of the subservicers of the trusts, and this was an entity that had engaged the national network of law firms that filed the collection lawsuits. The consent order was based on essentially the same allegations as were in the district court complaint that I just described. So in the lawsuit, the CFPB is now seeking to hold the trust liable for the very same conduct that it has now held one of the subservicers liable for. And after the court denied the order to the motion to approve the consent judgment, as Barbara described, because it found that the proper trust parties hadn't consented to that judgment, the CFPB was left to litigate a lawsuit that it had thought that it had settled. And somewhat surprisingly to me, the CFPB kept fighting, even under then CFPB directors Mick Mulvaney and Kathleen Kraninger, who easily could have walked away from the case after the embarrassing denial of the motion to enter the consent judgment. So the consent judgment motion was denied, and the trust and various trust parties moved to dismiss the complaint, and the motions to dismiss raised two threshold legal issues. One related to the constitutionality of the CFPB and questions of ratification, and the second related to CFPB jurisdiction over the trusts themselves for claims of unfair and deceptive practices. So with respect to constitutionality, while all of this was happening, the Supreme Court a couple years ago in a case called Selah Law had held that the CFPB's structure was unconstitutional because the agency, as Congress had set it up, is headed by a single director, and the statute says the director could only be removed for cause by the president. The Supreme Court said that was improper, that the president was able to remove the director, and said that the agency can now continue to function, it's just that the director is removable by the president. But the Selah Law decision left open some questions about pending enforcement actions of the agency. And in response to that decision, the CFPB took steps to formally ratify its earlier decision to file suit, saying, okay, well, now that we're constitutional because our director can be removed by the president, we hereby ratify this earlier decision. But that ratification came outside the statute of limitations for filing the lawsuit. And the trust parties argued that the case should be dismissed as having been filed too late. And the district court agreed. It dismissed the case, finding that ratification was necessary and that ratification had come too late, and that the CFPB had not demonstrated it should benefit from any equitable tolling of the statute of limitations. But the court allowed the CFPB to file an amended complaint to allege additional facts regarding equitable tolling. The CFPB did file that amended complaint, but then two other things happened that substantially changed the landscape. First, the Supreme Court, in a case called Collins versus Yellen, issued a ruling, and that case involved the constitutionality of the FHFA's structure, also headed by a single director, and put a little more gloss on its prior ruling in SALA law. And a new judge was assigned to the CFPB's case at the district court. And the trust parties, again, moved to dismiss the CFPB's amended complaint. And the district court, this time on the constitutional issue, ruled differently. And the court held that the Supreme Court's intervening decision in Collins stands for the proposition that a constitutional removal defect, like the one that the CFPB had, doesn't negate prior actions an agency has taken so long as a director of the agency had been properly appointed. And so Rich Cordray, who was the CFPB director, had been properly appointed when the case was filed in 2017. The district court said under Collins, it doesn't matter if there was a constitutional defect in how Mr. Cordray could be removed. The filing of the case was valid. Ratification wasn't even required, and therefore the court didn't have to address the timeliness of that ratification and deny the trust party's motion to dismiss on those grounds. And that brings us to the heart of the matter, which is the question of whether or not the CFPB has jurisdiction over a securitization trust for purposes of enforcing the prohibition on unfair, deceptive, and abusive acts and practices, or UDAAP. The CFPB's UDAAP jurisdiction is by statute limited to covered persons. And covered persons is defined in the statute as a person or an entity that is engaged in offering or providing a consumer financial product or service. Everyone agrees that debt collection, including filing collection lawsuits, is a consumer financial product or service. But the trusts and the trust-related parties argued that the trusts themselves were not engaged in that activity, that they are passive, pass-through entities, that as the CFPB itself alleged in its complaint, the trusts have no employees and therefore couldn't engage in any activity, and that it is the servicers and the sub-servicers who are the ones who are actually engaged in debt collection. And again, remember, the CFPB, in fact, brought an action against one of those sub-servicers. The district court disagreed with this argument. It started its analysis by looking at what the term engage means, and relying on some dictionary definitions, the court said that engage means to embark in any business, or to enter upon or employ oneself in an action. And relying on that definition, the court said, quote, that definition is broad enough to encompass actions taken on a person's behalf by another, at least where that action is central to his enterprise. The court noted that collecting on the underlying student loans is indeed central to the trust enterprise, that collecting on those loans is necessary to pay the note holders. And the court also focused on the fact that the debt collection lawsuits were brought on behalf of the trust with the relevant trust named as a plaintiff in the action. And the court looked at that fact and said, look, the suits couldn't proceed without the trust's involvement because of the legal rule that a party must assert his or her own legal rights and interests. So this was the trust asserting its rights in a lawsuit. To quote the court, it said, the sub-servicers could not have collected any debt without the trust say so. And therefore, quote, the trust cannot claim that they were not engaged in a key part of their business just because they contracted it out. The court's decision is now, there's a pending motion to certify that decision for interlocutory review at the Third Circuit, and we'll know hopefully shortly whether that certification is forthcoming or not. But this is the first time that the court has held that a securitization trust is a covered person and is therefore subject to the CFPB's UDAAP authority, notwithstanding its passive pass-through nature. And if the decision stands, it has potentially broad ramifications for the securitization industry, and in particular consumer loan securitizations. And to talk about those implications, I'll turn it back over to Barbara.
Thank you, Uri. So again, as Uri just said, the language of the CFPA and the assertion that special purpose trusts with no employees engage in servicing through their servicers is certainly broad, unclear, and untested. And certain facts did seem to get the court's attention, in particular that the collection lawsuits on behalf of the trust were being brought in the name of the trust and not the servicers. So what are the potential implications? For example, can investors rely on indemnification claims against servicers for bad conduct? Maybe, but that raises the question of their creditworthiness, and in the CFPB's view, and maybe also as a matter of public policy, fines and penalties are not indemnifiable. Could the U.S. government pursue a judgment against the trusts for payment of these fines, penalties, and restitution amounts and try to enforce it? Again, maybe, but at least in term deals, it may be difficult for that lien to have priority over the trustee's lien. In revolvers, that may be a different question. So I'm going to pause there and now turn it over to my partner, Steve Kaplan, who's going to talk in greater detail about this issue in the context of consumer products generally.
Thank you, Barbara and Ori. Let me start by noting, as Barbara said, that this matter obviously involved student loans. That being said, there's no reason to think that the CFPB will limit its view on this issue to student loans, and it could apply to other consumer financial products. Moreover, it's unclear what the market response will be to the action. For example, will trustees reconsider structures or seek more stringent indemnities and transaction structures in which they hold title to serviced assets, such as in common law trusts? Will there be any other reaction from the trustees or from other participants? So that leaves us with questions related to how can parties mitigate risks related to potential CFPB liability while at the same time considering other state law and risks. First, parties should ensure that they do not engage in activities or include language that triggers potential risks under applicable law. For example, they should not appoint a servicer as an agent. They should not engage in an activity that directly triggers liability under applicable consumer financial protection law. Those are the obvious things. Other things that should be considered include making sure that the risk factors, or at least considering that risk factors that appropriately and adequately address the risk. Second, ensure that accurate and appropriate description of duties and responsibilities. For example, limit discretion and ensure that objective criteria apply to servicer and other third-party actions. Also, parties need to ensure that they do not engage in an action that would trigger state licensing requirements. For example, state licensing requirements may be triggered by virtue of holding legal title to the underlying asset. They may be triggered by engaging in a certain activity, for example, under a state collection agency law, by initiating a lawsuit. So the parties also need to ensure that the appropriate parties engage in the activities that could otherwise trigger applicable laws. So these are some of the ways that parties can potentially limit risk and ensure that they do not end up in the same place as the parties in the current litigation. Thank you all for participating. We hope that this has been helpful, and as Ori said at the beginning, if anyone has any questions, please do reach out to us. Thank you.